Forbes did. Who is this guy?
Outside.
Are you?
Does he need the hearing things? Yes.
Okay,
Mr. Dabney, you need the hearing thing, that you need some assistance on that? Okay, they won't fit over that hat you're inappropriately wearing in my courtroom. There we go.
Nice hat though. I do like. Slide it. Okay. Wherever you like, put it down. Yeah.
Oh, who is this?
So put it down here so you can like this.
There we go.
Good morning again, Your Honor. Odatello, Assistant Public Defender on behalf of Mr. Forbes Dabney.
Okay. Who am I talking to?
Not entirely sure, but it would be me.
And your name is?
It's right there in bold letters in the front.
I see a judge and a period, a J and a period. I don't know
Yes,
your name.
it's all there.
Okay, that's all there.
Yes, that's all there. Your Honor, today's the date and time set for, I believe, competency.
So
At
this is a special hearing, right?
Yes.
I come here for what they call that thing, judge jury thing. That's today?
Today is the competency on your case.
I didn't ask for that. I asked for a judge
There's a
Or
judge
jury.
today. There's a judge today present.
Got one.
We got one
to
today.
do a jury, what is that the thing called, a judge? I had a stroke,
Yes, sir, Mr. Dabney.
so I have names.
Let me help you out here. You're very welcome, sir.
I come for a jury. What do they call that? A thing when they got a
A trial.
trial,
Yes.
attorney by trial, attorney by trial?
We're going to get through this today,
I thought that was today.
not today.
Why not?
That's another part of the process. Okay. We're going to help get
I
through
just
this.
need to get the process going. With the who the guys, the police officers.
There are police officers, there's a judge.
Are they
there
gonna be here?
attorneys. I don't believe they're here today. Okay.
Mr. Dabney?
We get them named in?
We're going to try to get them there. We're going to do a lot of stuff in your case. Okay. But today is for competency. Okay.
I don't need that.
Yeah.
Well, the judge is going to help us figure that out.
Yeah.
Okay.
Hi,
Hi. You good?
your first name is? Okay,
Well,
what's going on?
it kind of is.
What's
Yeah.
going on?
What's going on?
Yes,
Thank you.
Well, we're waiting on a report on your case. We don't have it.
what, you said again, a report?
A report on your case regarding competency, so that then once we get that, we hopefully can move the case along.
Okay, then we're gonna do that at a different time?
We're gonna do it at a different time.
Well, can we move?
Pardon?
Can we move
Can we move
to another time?
to another day?
Yes,
I'd be more than happy to.
thank you.
All right, so here's what I'm gonna do. I'm gonna adjourn this competency hearing. 1 month out is what, the 18th, 19th,
20th.
20th, June?
Yes.
So I'll move the competency hearing to June 20th, 2024 at 9 a.m. Okay?
Thank you.
You're welcome, Mr. Deb.
I did not ask for that.
You didn't ask for what?
Whatever you got there, right there. What is this thing you're getting ready to do? I didn't sign up for that.
Oh, I know, but yes, you did.
Oh, yes.
Yeah, no, okay, I signed you up for it.
You signed me up.
Yep, I did.
By what case number?
By what case number? This case number.
Oh, okay.
Okay,
Yeah.
Okay.
Move on.
yeah, we'll
We'll
move
talk
on.
about it outside, Mr. Deb. We'll
All right.
take care of it. Okay.
Fine,
You wanna take that
continue.
For you?
Hmm?
You want to take this for you?
Take it, please.
Yes, sir. All right. There you go. Thank you.
Thank you, Mr. Dabney. Have a
Thank
great
you
day.
kindly, Judge. Appreciate that.
Yeah, put the hat back on. All right, go ahead. Get it wrong. What are we doing?
I do believe that there is a bond violation that needs to be addressed, as well as I need to address the defendant's phone privileges.
Yes, Your Honor, that is our understanding. Go ahead, Mr. Rosa.
Your Honor, are you in receipt of,
I have the police report. But yes, go ahead.
I am extremely concerned as to the tamper from May 12th with the defendant's Tether. But I am also concerned because that is exacerbated by the fact that after the defendant was taken back into custody, he called the victim no less than 8 times to her direct number from his own PIN. I have not had an opportunity to listen to those calls. I did make Mr. Ovitella aware of those calls, and I have made a request for those calls to be released to him so that he could hear them. I did receive a note from Ms. Defendant that she had an opportunity to listen to some of those calls, and it is a lot of conversation about the Tether, not charging it, not understanding what's going on, and the victim asking why this was happening and why he did this to her. At this point, he was taken into custody after an arraignment, after a bond violation, after he was well aware of the no contact and continued to contact. And I think at this point, his bond currently being set at $5,000 with a 10% privilege is grossly inappropriate.
That's not where it is right now. It's been denied, but yeah, but go ahead. Anything you want to say? But let me just make sure the phone calls occurred after he was brought in for the bond violation. There were more phone calls.
From May 12th at 8:24, May
Got it.
12th at 13:50, May 12th at 13:59, May 12th at 18:45, May 12th at 18:54, May 13th at 15:15, May 14th at 18:17, and May 14th at 19:58. I did not check again after probably about 2 p.m. yesterday, so there could have been more, but as of yesterday at about 2 p.m., that was the last tally that I had.
It does sound impressive, Your Honor, but I have not heard the phone calls or anything of that nature. And until I do, I'm not able to address them at this time. So I would ask for an adjournment on that until we can, until I can hear them and we can address that.
This is his probable cause also today. Emily,
Yes,
this is his probable cause and bond violation.
correct.
I'll adjourn the bond violation as well as the probable cause, May 23rd, 2024, 9 a.m. Bond at this time, given everything that I've seen, his bond is revoked.
Can we revoke his phone privileges as well?
I would state that's premature, Judge, because I haven't heard anything yet, but it's
Really? I know it's up to me, but why would they be premature if they're to the victim's number?
Yeah.
Regardless of the contact,
I leave it to the court, Your Honor. I'm just advocating for the client.
Defendant phone privileges are revoked pending the hearing. Thank you.
Thank you kindly.
The courtroom session begins with an unusual and somewhat tense interaction between the judge and the defendant. Mr. Forb, as the hearing starts, the judge immediately notices that the defendant is wearing a hat in the courtroom and asks him to remove it so he can properly use the courtroom hearing device. The moment sets the tone for what quickly becomes a confusing exchange when the judge asks the defendant to confirm his identity. Mr. Forb appears unsure about who he is speaking to and struggles to follow the conversation. Instead of answering directly, he points out the judge's name on the bench and says he only sees initials. The judge attempts to guide the discussion, but it becomes clear that the defendant is having difficulty understanding the purpose of the hearing. The assistant public defender explains that the Hearing scheduled for today is a competency hearing, which is meant to determine whether the defendant is mentally capable of understanding the legal proceedings and assisting in his own defense. However, Mr. Forb insists that he did not come to court for that purpose. Instead, he repeatedly states that he came for what he describes as a judge and jury thing, clearly. Referring to a trial, the judge patiently explains that a trial cannot occur yet because the legal process requires several steps beforehand. The competency evaluation is one of those steps, especially when there are concerns about whether a defendant fully understands the case against them. Throughout the conversation, Mr. Forb continues to express confusion. At one point, he mentions suffering from a stroke, which may explain some of the difficulties he is experiencing in following the proceedings. Because the court has not yet received the official competency evaluation report, the judge decides that the hearing cannot move forward at this time. To allow more time for the report to be completed, the judge adjourns the competency hearing and reschedules it for June 20th, 2024, at 9 a.m., although the judge explains the decision clearly. Mr. Forb continues questioning why the competency process is happening at all, insisting that he never asked for it. The judge calmly responds that the court has the authority to order such evaluations when necessary. After resolving the competency issue, the court moves on to a bond violation matter involving the same defendant. The prosecutor raises serious concerns about the defendant's behavior while he was out on bond. According to the prosecutor, the defendant allegedly tampered with his electronic Tether monitor on May 12th, raising immediate concerns about compliance with his release conditions. Even more troubling, after being taken back into custody for the violation, the defendant reportedly called the alleged victim multiple times from jail. Despite a strict no-contact order, the prosecution presents a detailed timeline of the calls. Records show that the defendant contacted the victim at least 8 times over a 2-day period, with calls occurring repeatedly on May 12th, May 13th, and May 14th. These calls were made directly from the defendant's jail phone account. The prosecutor argues that these actions demonstrate a clear disregard for the court's orders and suggests that the defendant's previous bond conditions were not strict enough given the circumstances. The defense attorney responds by explaining that he has not yet had the opportunity to review or listen to the recorded calls. Because of that, he argues that it would be unfair to fully address the allegations without first reviewing the evidence. The defense requests additional time to examine the calls before responding in detail. Despite this argument, the judge focuses on the fact that the calls were allegedly made directly to the victim's phone number, which already violates the no-contact condition regardless of what was said during the calls. Based on the information presented, the judge makes a decisive ruling. The court revokes the defendant's bond and orders that he remain in custody. In addition, the judge revokes the defendant's phone privileges while the matter is pending, preventing further contact attempts. Finally, the judge schedules the probable cause hearing for May 23, 2024 at 9 a.m., where the court will continue reviewing the case and the alleged violations. The hearing ultimately highlights the court's concern about both the defendant's competency to stand trial and his compliance with court orders. With a competency evaluation still pending and serious bond violations under review, the case moves forward with stricter supervision and closer scrutiny from the court.